Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract and independent contractor agreement issues. Today, I'm going to talk about how to write a termination notice. So, assuming you have a signed employment agreement or perhaps a signed independent contractor agreement, both of those agreements will always include a termination section which states how you can terminate the agreement. There's usually 4 ways that you can terminate an agreement. 1, if the term just ends. So let's say you have a 1-year contract. There's no language about automatic renewals. Neither party wants to continue the relationship after the 1-year period. It just ends. That's one way the contract can be terminated. Second, by mutual agreement. So if both parties agree, it's not working out, let's just move on. That's an easy way for a contract to be terminated. The third is for cause. So if one party breaches the contract, usually there's also what's called a cure period, which, so for instance, let's say you're not being paid the amount that they said they would pay you. You give them written notice. Hey, you said you would pay me this amount. You're not. You're in breach of contract. Normally the contract will state how many days they have to fix the breach. And then if they don't fix the violation or the breach, you can terminate the contract immediately. And then the fourth way, and usually the most common way, is without cause termination. What that means is either party can terminate the agreement at any time for any reason with a certain amount of notice to the other party. And so that's what the kind of termination letter comes into play. So for most industries, it's somewhere between 30 to 90 days. Healthcare, it's a little bit more to accommodate continuity of care. Sales, software, anything like that, 30 days is kind of the standard. So once you determine how much notice you have to provide your employer, then you need to figure out what needs to go into the letter. If you're just terminating the contract without cause, you don't need a justification for why you're terminating the contract. Sometimes people come to me and they've written out 2 pages of all the reasons why they're terminating the agreement. It doesn't matter. If you're going to terminate the agreement without cause, you simply need to say in your letter, per the agreement, I am giving you 30 days notice. I am terminating the contract without cause. My last day of employment will be X date. If you have any questions, let me know. Thank you for the opportunity with this job. That's all it needs to say. It doesn't need to have a huge diatribe about all the problems that exist or all the reasons why you're leaving. As I said before, short and sweet. I'm terminating the agreement per this section. I have to provide 30 days notice, so my last day of employment will be X. Thank you. And that's it. The last thing you need to think about is where to send the notice to. So in the agreement, there will be a notices section at the end of it that will state to who you have to send notice of termination and how. So most contracts will state it has to be in writing. So if you just verbally tell your boss, that's not enough. It has to be in writing. It has to be sent via either hand delivery, certified mail. More places nowadays will accept email, although most don't. So look to the notices section and see who you have to give the notice of termination to, how it has to be delivered, and then what needs to go into it. And if you have those 3 things, the written notice with the proper language, sent to the right person via the right delivery method, then you've given proper notice and you're good to go once your agreement ends. Now, a couple of considerations. When you give notice, you need to see if your employer can accelerate the termination. Meaning, if you have a 30-day notice, is there language in there that says once you give notice, the employer can accelerate the date of termination to immediately? And then do they have to pay you or not for those 30 days? So you shouldn't sign a contract that says they can accelerate the date of termination and not pay you. That's bad. So if you have a 30-day notice, and the employer wants you to go early, they should still pay you for those 30 days. And then one other consideration is bonuses. Many times the contract will state if you have a bonus that you haven't received yet, you kind of forfeit the right to get it if you give, any kind of notice of termination. So look into the language of the contract and see how are the bonuses paid, how is the compensation calculated if you leave, before the end of the quarter or the year, whatever it is. I've had plenty of people who have just given termination on the wrong date and have left a lot of money on the table from bonuses that they have already earned. The language is extremely important when it comes to this. Many times it'll state when it's paid out. And so, I have a professional who's earned a bonus, given notice, expect to get paid, but their date of termination is before the date that the bonus would normally be paid out. They don't get the bonus. So anyway, so that's how you write a notice of termination letter. If you have any questions about providing notice to your employer, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. I appreciate you watching the video. Thanks.